Hello, Michael, hello, Rhiannon, and Jason. Good evening, everyone. So we'll begin in a minute. Hello, Jackie. Okay, we could begin. Now, before we start discussing the topic for topic 2, would there be any question that you might have or anything you'd like to raise? Let me begin, though, by talking about the legal memorandum assessment. I just needed more time to finish it. So I will be able to post the legal memorandum assessment by tomorrow. From Jason Manjo, can you please make these slideshows available? Okay, good. I'll do that, Jason. So I'll make sure that whatever PowerPoint slides there are, I'll post them as well. So Jesse seems to have a very handsome son here. Hello. Okay. Where will I find the assessment? When it will be posted, it will be right underneath my name on the Moodle page. I will post it there. Okay, so we could probably begin. Would there be anything else? Would there be anything that you may want to? Yep. So as far as the vacation week is concerned, it actually starts on the 24th of March. I think I put it in the email earlier. I made a mistake. I thought that the vacation week was going to begin on the 30th of November. That's obviously wrong. So the vacation week should begin, I think, on the 24th of December until the 3rd of January. And I've actually posted as well the important dates on in Moodle. 2 weeks. Yeah, I've actually seen the calendar. So the vacation week is from the 24th, I think, up to, let me just check the Moodle page. Yeah, so the vacation week would be, yeah, oh, it's from December 25, a Friday, up to the 3rd of January, which is a Sunday. So that should be about, is that 2 weeks? I don't really know. I'm just following the whatever is in the CQ Uni calendar. So whether or not that's actually 2 weeks, I'm not really sure. But that's according to the calendar. Okay, anything else? Oh, it's 11 days, okay, yeah. Anything else so we could proceed? Okay, let's begin. So for tonight, our objective would be to, after studying this topic, you should be able to discuss and explain oops, it's the wrong objectives. Hold on. Yeah, it should not be that. So we'll just skip the objectives. Our purpose for tonight's tutorial would actually be to learn more about the scope of judicial review and when judicial review is available. So that's going to be the focus of tonight's tutorial. So we will begin by looking at tutorial question number 5, which is the first tutorial question for tonight. Can I request someone to read the tutorial question for us? Oh, that's interesting. I'm sorry. I just noticed that I'm using CQ Law 2 Zoom license, which actually limits the participants to only 25. So I should, or maybe Stephen has changed the Zoom licenses, because at least I'm seeing 30 people here. I'm just concerned that there might be some students who are unable to join tonight's session because I used CQ Law 2 as the license. Hopefully not. But at least I'll keep that in mind that next time I'll be using the one with the with a license that would allow more students to participate. Okay, can I get a volunteer to read the first question?
I'll read it for you.
Thank you. Who would that be?
I'll read it for you, Manjo.
This would be, sorry, couldn't, who was that?
I'll read it for you.
Okay, thank you. Go ahead, please. Yes, go ahead, please.
After years of working as a disability support worker, Sharon Hills decided to set up her own business providing support to disabled persons. The Disability Support Workers Act Commonwealth requires that operators, owners or managers of businesses seeking to provide services to persons with disabilities must have a business license from the Australian Department of Social Services. Such a business license may be given only to persons who have had professional experience as a disability support worker for 5 years and who are of good moral character. The Act also provides that an application for a license must be made not later than 30th June of the same year. Sharon applied for a license on the 18th of June. However, staff of the ADJR did not accept her application because her documents showing her years of professional experience as a disability support worker were incomplete. She returned on the 27th of June to submit further documents, but these were still considered incomplete, and so her application was not accepted. On 30th of June, she returned with the complete set of documents on her professional experience, but was then asked to provide further evidence relating to her good moral character. She returned the next day, or 1st of July, to submit the necessary documents, but the ADSS refused to accept her application because it had been submitted after the deadline. Sharon is frustrated and angry that her application was not accepted and has come to you for legal advice. Assume that recourse to the Administrative Appeals Tribunal is not available. Advise Sharon on whether judicial review is available and why.
Okay, thank you, Elizabeth. Thank you. There's even a more longer one. Okay, that's tutorial question 9, I think. It's even longer, much longer. Okay, can I get answers from everyone in the chat box? Can you indicate whether or not judicial review is available and why? Okay, can you indicate why? Why would judicial review be available? In other words, what are the elements that need to be shown before we can say that judicial review is available?
Man?
Yes? Who would that be? Jacob, was it?
Yeah.
Yes, Jacob, yes.
I couldn't paste my answer into the chat box thing. Could
Okay.
I read out my response?
Yep, go ahead, please.
Okay. I don't know how right it is.
Go ahead, not a problem.
If the AAT is not available to Sharon, she may appeal to a Supreme Court in her jurisdiction concerning her grievance related to a late submission for a business licence. Additionally, she may attempt to seek a judicial review with recourse to the Administrative Decisions Review. Judicial review is when a court looks at the way the original decision maker applied the law and the process they followed when they made their decision. Considering Sharon first applied for the business licence on the 18th of June, 12 days before the close of submissions, and was then required to return on 2 separate occasions with further additional documentation, thus resulting in her late submission, there appears to be an issue of departmental efficiency. Instead of providing Sharon with all the information outlining the required documentation under the Disability Support Workers Act, during her initial visit to the ADSS, she was drip-fed the information which resulted in her missing lodgement during the submission period. The DSW Act nor the ADSS are excluded from judicial review under Schedule 1 of the ADJR. Also, Sharon is aggrieved by a decision to which this Act applies, that's subsection 5, paragraph 1 of the ADJR concerning her late submission. Further to this, it appears a breach of the rules of natural justice occurred in connection with the making of the decision. That's paragraph A, concerning the same section, concerning the lack of efficiency regarding execution of departmental procedure resulting in Sharon's late submission of her application for business licence. Further, even if further bars arise in the form of legislative exclusions to Sharon's application for judicial review, natural justice requirements are not always excluded merely because of discretionary power. Because a discretionary power is applicable, that's courts and Commonwealth, CLR. Although Sharon would be advised to keep in mind that there is no general principle of natural justice that requires reasons to be given for administrative decisions. Public Service Court in New South Wales and Osmond 1986 High Court.
Thank you, Jason. That was quite comprehensive. I just thought it was overly comprehensive.
Yeah, sorry.
Okay, I'd like to give Rhiannon a chance. So thanks, Jason. You were actually in the right track. Although there was too much information, I was trying to figure out, what you were saying.
Manjo, it's Jacob.
Yeah, Jacob. Yeah, thank you, Jacob. Rhiannon says no, thank you. What exactly are the elements that need to be established for us to say that judicial review is available? What are the elements that need to be established? Can somebody tell us? What do we need to show before we can say that judicial, so one would be justiciability. Okay. What else? Okay, there we go from Brad. So Brad, do you mind, Brad Marler, do you mind taking the floor using the mic? Brad, if you could. Brad, is it okay? Okay, Brad might have a problem with his mic. So if you look at the answer of Brad, there are at least 4 things that need to be there. He's just missing one more. There must be a decision. There must be a decision. Brad, would you like to explain your answer? Oh, his mic is not working. Okay, that's fine. So there must be a decision. The decision must be of an administrative character. The decision must be made under an enactment, as defined in section 3, subsection 1, and the decision must not be an excluded decision. Okay, and as Catherine also suggested, there should be standing, and there should be a ground for review as well as a remedy. So, and standing is also in relation to the need for the person to actually be aggrieved, as pointed out by Steve. So Sharon must be aggrieved. So let's look at this separately. So was there a decision? Was there a decision? So the answer is yes, according to Vivian. Why was there a decision, Vivian? What exactly was the decision here? From Libby as well, it's a yes. So what exactly was the decision? There. So from Vanessa, yes, there was a decision not to accept her application, which led to her application being denied. So there is a decision. Now, was the decision of an administrative character? So there is a requirement that where are we now? Following the statements of Brad, was the decision of an administrative character? Yes. How do we know that the decision is of an administrative character? So the answer is essentially yes. The decision is of an administrative character. But how do we know that it is of an administrative character? From B, because it is made under an enactment. Would it mean that if a decision is based on an enactment, it is necessarily one of an administrative character? From Vicky, because it is neither judicial or legislative in character. So if we're looking, from Peter as well, yes, it wasn't judicial or legislative. So if we're looking for a shorthand way, for a simple way to determine whether a decision is of an administrative character, we simply ask one, is it a judicial decision? So you would know it's a judicial decision if it is coming from the courts, whether it's a state court or a federal court. is it a legislative decision? Meaning, is it something that is emanating from the parliament? So in that case, you would know that it is a legislative decision if it is one that broadly affects everybody. So a law, for example, affects everyone. Whereas a decision of an administrative character typically affects specific individuals or a specific person, as in this case. So in this case, the decision, which was about an application not being accepted and therefore the refusal of the application, was only affected Sharon. Okay, so we know that it's not one of a legislative character because it only affected Sharon and not everyone else. So typically, if it is a legislative decision, it would affect a broad sector of society or a broad sector of people. So the shorthand way of determining whether or not it's a decision of an administrative character would be one, is it judicial or legislative? And two, is it a decision made by an executive body or a body that belongs to the executive department? We know in this case, it is a body that belongs to the executive department because it is a decision by the Australian Department of Social Services. So we've got that cleared. And then, according to Brad, the decision must be made under an enactment. So that's a question. Was this decision made under an enactment? Yes, so Kim is asking the question, is it a decision made under an enactment? It seems to be because the decision was based on the Disability Support Workers Act. So it was based on the Disability Support Workers Act, so it was based on an enactment. And if we look at the definition of the enactment, it goes beyond just a statute. An enactment can actually include a regulation that is created or drafted on the basis of a statute or a law that is passed by the parliament. Okay, now, and as pointed out by Vanessa, yes, the act, because the act specifies the requirements that are necessary to obtain the license. So we've clarified that there is a decision, and the decision being the refusal to accept the application. There is a decision of an administrative character because it's not judicial or legislative, and also mainly because it's a decision coming from the Australian Department of Social Services, which clearly belongs to the executive department. But thirdly, it is a decision that is based on an enactment, which is the Disability Support Workers Act. And the fourth one being, according to Brad, the decision must not be an excluded decision. So we will assume that this is not among those which are in the schedule of the ADJR Act, because I made up this specific scenario in the first place. So it couldn't have been an excluded decision. So typically when you look at the excluded decisions, they would relate, for example, to decisions by the Governor General or decisions of the ASIO, or the Australian Security Intelligence Office. And more importantly, there must be the issue of, well, we assume there's justiciability here. There must be the issue of standing. And for there to be standing, the applicant for judicial review must show that he or she is an aggrieved person. In this case, we assume that yes, Sharon is an aggrieved person because her right to have her application accepted was denied. There's also the question of ground for review. And what's the ground for review here? Probably the ground of natural justice, which we will explore even deeper in the days or in the weeks ahead. There's also the question of would there be sufficient judicial remedies if one were to go to the courts? And the answer is yes, under the ADJR Act, because although typically the power, as we will later on see, the power of judicial review is usually limited to setting aside a decision or affirming a decision. Under the ADJR Act, there is, under Section 16, it is within the power of the Federal Circuit Court or the Federal Court of Australia to actually compel an officer to act in a specific way. And in this particular case, it could mean that the Federal Circuit Court can order the Australian Department of Social Services to accept the application of Sharon. Okay, so that was just the initial groundwork that we were trying to go through for us to get a sense of what is required for there to be judicial review. So we're going to move on. Yes.
Can I ask a question? Sorry.
Yes, go ahead, Kim.
Just when we're asking ourselves whether or not there has been a decision under an enactment, if the Act simply said an application must be received within a certain time frame, and there's no discretion whether to accept late applications, if they're not exercising the discretion, are they making a decision? If they're simply following verbatim what the Act says, is there really a decision being made?
Okay, that's a very good question. We make a distinction between whether or not there was a decision and whether or not the decision was lawful. Those are two things. Okay, the first question we need to ask is, was there a decision based on an enactment? The answer seems to be yes. There was a decision in the sense that the application was denied because in the first place, the application was not accepted. So there was a denial of the application. So that constituted the decision. Now, the second question really is, was that decision lawful or contrary to law? So that's a separate question altogether. Now, if we speak of judicial review, the question really is, was the decision lawful or not? Because the judicial review is limited to a question of the legality or lawfulness of a decision. So in this case, we know that there was a decision of an administrative character based on an enactment, which was the decision to deny the application because the application had not been accepted. Now, as to the question of whether or not the decision comprised a legal question or a factual question, it appears to be that there is a question of legality here because of the denial of the right to natural justice, which under the ADJR Act is actually a ground for judicial review. So there is a denial of natural justice because there was a failure to give Sharon an opportunity to be heard. Before her application was denied, she should have been given an opportunity to explain why her application, the submission of her application was delayed in the first place. Now, having failed to provide that right to Sharon, there was a violation of the right to natural justice, which is a ground for judicial review under the ADJR Act. So we're going to move on to question numbers, the second question, which is question number 6. Can I have a volunteer? So from Libby, I see my error answer based on what the likely outcome would be. So that's correct. That's good. You've seen that, Libby. So in other words, the crux of the question there really was, we need to know were the elements that were needed for there to be judicial review to be available, were they being met? Were the elements there? Because if one of the elements was missing, for example, it was not Sharon who complained, but probably the husband, then there would have been a question of a problem with standing. Or if it had been a labor union of which Sharon was part of that made the complaint, there would have been a question about standing again because the labor union would not have sufficient interest or right in relation to the decision. Okay, so moving on to tutorial question number 6. Can we have a volunteer to read the question for us? It's just a short question anyway. Can I get a volunteer?
Okay, I will read it.
Oh, that'd be Sarah. Thank you, Sarah.
The Australian newspaper reported that a federal government commissioned report has detailed widespread and systematic abuses of boat refugees in Australia's refugee facility on Manus Island. The Australian Refugee Consortium, an Australian non-government organisation, asked the Minister for Immigration and Border Protection, who commissioned the report, to publish it, but he refused. The consortium has approached you for legal advice on whether it has valid grounds to apply for judicial review of the Minister's decision not to publish the report. Give your advice.
Thank you. So can I get everyone to post his or her answer in the chat box? Give your advice. Would there be a valid ground or valid grounds to apply for judicial review? It's a yes or no. And if you could, explain why you think there might be no or there would be a ground for judicial review. If you could just explain why as well. Explain your answer a bit. So is it a yes or no? Okay, so we're getting some answers here. So a lot of the answers, and the reason I'm reading the answers in the chat box, it's because those who might be watching the recording are not able to see the chats in the chat box. So I'm going to be reading some of them. So most of the answers here relate to the fact that there doesn't seem to be any standing. What do we mean by this? No standing. Who doesn't have standing? And why not? Let's begin with that first. So there are two answers here. One is, no, there actually now would be three answers here. Coming from Jackie, it's made under a prerogative power. So I'm just gonna put them on the screen for those who will be looking at the recording later on. So there are three reasons that were posited as to why there couldn't be any room for judicial review. One would be the lack of standing. And if somebody could explain this to us later in a short while. The second one was, what was that? The second one was in relation to a political decision. So if somebody could explain this, and there was a good point made by Jackie in relation to prerogative power, which is good. Okay. Okay. Can somebody explain this to us? First of all, what do we mean by lack of standing here? Why? Who doesn't have a standing? Is it necessary to take the floor? Is it sufficient we get the answer from the chat box here? Okay, so it seems to be that if we look at the answer of, for example, of Peter, was it? Every time somebody writes something in the chat box, the whole thing just moves and I couldn't see it. So from Peter Fierick, the applicant cannot demonstrate a legal interest affected by the administrative decision. So in that case, Peter is referring to the Australian Refugee Consortium, that the Australian Refugee Consortium cannot demonstrate the legal interest affected by the administrative decision. Because in the first place, even if the minister refused to publish the report, how would that affect the Australian Refugee Consortium in the first place? So we have a problem with standing. And as we said, for there to be judicial review, the applicant for judicial review must be able to show standing. In this case, it seems to be quite clear that the Australian Refugee Consortium cannot be affected by the decision to publish the report or not. Okay. Now, secondly, there's the issue of the decision being a political decision. Can somebody explain this? What do we mean by this? Can somebody use his or her mic to explain what we mean, what is meant by this being a political decision, and therefore, you cannot have judicial review. And then there's a statement here from B that it wasn't made under an enactment, and we're going to go back to that. So it was not made under an enactment. We're going to go back to this. Okay, can I just get somebody to explain this notion of political decision? What does that mean? And what implications?
Manjo, it's Vivian.
Yes. Thank you, Vivian.
I would say that it would be the policies of the government or of the minister that have impacted on his decision not to publish those documents. Therefore, it's more of a political interest sort of thing that the judges normally say is beyond their powers to review. Okay,
good. Why is that, Vivian? Why is it that if a decision is of a political character, judges or courts typically would refrain from accepting or passing judgment on such a decision?
Because they say that the judges say that the politicians are actually the ones that are the most credible to talk about the policies of the government, and you've got your separation of powers, and you don't want the judiciary overstepping their mark and impacting on the political policies.
Very good.
Does that make sense?
It does. So actually, most of you got the answers correctly. It's a question of separation of powers from B, from Erin, from Forbes, from Audrey, because the politicians have the mandate from the people, the judges don't. Yep. So from Vanessa as well as from Brad. So from Brad, for example, decisions that require the exercise of political judgment are best reserved to the executive branch as the representatives of the people. So when there is a political decision, courts will say that what is involved is a non-justiciable question and something that is best left to the elected officials. Okay. Prerogative power. What do we mean by this? How significant is that? So when somebody was saying something about not made under an enactment, what's the significance of making a statement that what seems to be involved is a prerogative power? Are we saying that if the power that is being used is a prerogative power, therefore it is not subject to judicial review? Is that what we're saying? What do we mean by that? Or how do we distinguish prerogative power from other powers? Can somebody explain what prerogative power actually means? Is prerogative power a decision made under common law rather than under statute? Quite there, but not quite right still. Is it about discretion?
Is this your cookie coin?
Mm-hmm. That's what's wrong, right?
What does prerogative power mean? I'm just gonna turn off the mic unless someone would like to say something, because we're getting some background noise. Would anyone wish to take the floor to explain what prerogative power means? No? Okay. So typically, when we speak of the powers of the executive, or even the powers of the legislature, for example, the main source of power of the executive or of the legislature would be the Constitution. We're looking at it from the viewpoint. Remember, we're talking here from the viewpoint of the federal government, which, as we know, is comprised of three branches of government: the executive, the legislature, and the judiciary. So they derive their powers essentially from our written constitution, which is the Australian Constitution. Now, however, the powers of the three branches of government, or at least in particular in relation to the executive, is not in fact limited to what is in the Constitution, because if you read the Constitution as to the powers of the executive, it doesn't actually say much what the powers of the executive are, unlike the powers of the legislature or of the judiciary, which are kind of more enumerated and more detailed. So in relation, therefore, to the powers of the executive, a lot of its powers are not in the Constitution. And we have what are known as inherent powers. So even if there were no written constitution, although we do have one, and even if there were a written constitution, we will have to assume that there are certain powers that are inherent in the executive for it to be able to perform its functions in society or as a government. So there are certain inherent powers, even in the absence of a written constitution, or even in the absence of a law or statute that is passed by Parliament. So some of these inherent powers, for example, would be the inherent power of the executive to declare war. You don't need a constitutional provision to empower the Prime Minister, for example, to declare war, or the power to enter into treaties, or the power to enter into contracts. So these are examples of powers that are inherent in the executive for it to be able to undertake its functions, even in the absence of any enabling law, whether it's based on statute or the Constitution. So that's what we mean by an inherent power. And because it is an inherent power, we might say that it's a prerogative power, because it is up to the executive to exercise that power or not. It is a power that is based on a prerogative on the part of the executive to exercise it or not. And therefore, the executive cannot be controlled either by the legislature or by the judiciary to exercise its powers in one way or another. So for example, the power to make war or the power to declare war, the legislature cannot compel the Prime Minister to declare war, or the legislature cannot compel the Prime Minister to enter into a treaty. It is a prerogative power. Okay, now, the fact alone, or even the power to, so even in the absence, for example, of a statute or law passed by the Parliament, you might ask whether or not would the Minister for Immigration and Ethnic Affairs, for example, have the power to actually prevent both refugees from entering into Australian waters, or would it have the power to turn them back? So in other words, the question is, do you need a law to be passed that would give the Minister of Immigration and Ethnic Affairs the power to exclude both refugees from the Australian territory. And B and Jerry C are saying no. So in other words, you don't. So in other words, if you don't need a law, what does it mean? You're actually admitting and acknowledging that the Minister for Immigration and Ethnic Affairs, as part of the executive, has an inherent power to exclude aliens and both refugees. You don't need the Constitution for that. You don't need a statute passed by Parliament for that. So it becomes an inherent power, and it is a prerogative power because it depends on the Minister to exercise it one way or another, or to exercise it or not. So it's based on a discretion. Now, so it's not just a fact that it's based on discretion, because when you look at the powers that are often given to members of the executive on the basis of an enabling law or a law passed by Parliament, that law would in fact give discretion to the executive to exercise the power one way or another. So it's more than the fact that because it is discretionary that makes it a prerogative power. Because even a power that is given by Parliament to the executive can give discretion and some flexibility to the executive. So that it's not because of the it being discretionary that makes it a prerogative power. It is prerogative because it is an inherent power of the executive, and it doesn't require the Constitution or an enabling law on the part of Parliament. So if the question is, if it involves the exercise of a prerogative power, would it mean that it is outside the scope of judicial review? And the answer is no. Okay? Because under Section 75 of the Australian Constitution, in particular Section 75(5) of the Australian Constitution, the High Court has the power to issue writs of mandamus, prohibition, or injunction in relation to acts or decisions of Commonwealth officers. So does the prerogative power come from the Constitution? No. It is a recognition that there are certain inherent powers on the part of the executive, even outside of the Constitution. Because if you look at the Constitution in fact does not enumerate what the powers of the executive are. Unlike when you look at the Commonwealth Parliament, for example, where Section 71 clearly indicates, or rather Section 61 clearly enumerates what the powers of the Commonwealth Parliament are. Okay. So we're clear on that? The fact that it wasn't made under, okay, the other question we have, so going back to the issue of prerogative power, so even if the power on which the executive makes a decision is a prerogative power, it is still subject to judicial review under Section 75 of the Australian Constitution. More importantly, under Section 39B of the Judicial Act of 1903, the Federal Court of Australia, as well as the Federal Circuit Court of Australia, have the power to review decisions made by Commonwealth officers. So it's not just the High Court, but the Federal Circuit Court and the Federal Court of Australia exercise concurrent jurisdiction with the High Court of Australia to review decisions of Commonwealth officers, and they also have the power to issue writs of mandamus, prohibition, and injunction. So that should be clear. Now, not made under enactment. What is the implication of this? The question being, if a decision was made not under an enactment, would it mean that that decision is no longer susceptible to judicial review? So let me repeat the question, because this was pointed out by somebody. Would it mean that if a decision was not made under an enactment, does it take that decision outside of the scope of judicial review? What's the answer? Is it a yes or a no? Or does it mean that, is it a yes? So you need a decision to be under an enactment for it to be subject to judicial review? Is that correct? Some are saying yes, some are saying no. Can somebody take the floor? Margie, Vivian, Kim, because you said no. Could you take the floor and explain what your answer is? Because there seems to be a disagreement in the class.
I may be wrong here, but I was going to say that I think it might take it outside of the ADJR Act, but that Act is in addition to the existing common law judicial review powers, I believe. And there's also, as you mentioned, a power in the Constitution for judicial review.
Very good. That's very good, Kim. So, as pointed out by Kim, as far as judicial review is concerned, the ADJR Act is only one of the sources of law for judicial review. But you have, the common law judicial review. You have judicial review as well on the basis of the Constitution. And you also have judicial review on the basis of statute. In particular, we speak of the Judiciary Act of 1903, specifically Section 39B. So even assuming that an administrative decision was not made under an enactment, it is still possible for there to be judicial review, either on the basis of the common law powers of judicial review, meaning these are the powers which are recognized as being inherent on the part of the courts to review decisions made by the executive. So there is that understanding that the courts can exercise their inherent power, even in the absence of the Constitution, even in the absence of a statute, to actually review decisions made by the executive. So you have so apart from the ADJR Act, you have as pointed out by Kim, you have the common law judicial review, you have the constitutional judicial review based on Section 75 of the Constitution. You also have a statute that provides for judicial review, in particular the Section 39B of the Judiciary Act of 1903. Okay, so we'll move on. It's 7:57. So we're going to have to skip one of the questions, the longer question, which is tutorial question 8, because it's quite long. So we're going to have to skip that. Okay, we probably have time to answer tutorial questions 7 and 9. Can I have a volunteer to answer question 7 for us? I mean, at least to read question 7.
Margie Manjo.
Maggie, thank you. Yes, Maggie, please.
The Stellar Innovations Proprietary Limited won a multi-million-dollar government contract in 2010 to build and maintain certain infrastructure projects as part of the Fast Track Infrastructure Stimulus Act 2010 of the Commonwealth. However, when Stellar Innovations Proprietary Limited sought to bill the federal government for a portion of the project that had been completed, the Minister for Infrastructure and Regional Development refused payment. The Minister asserted that the contractor failed to comply with a key condition of the contract. After the Minister refused to reconsider his decision to refuse payment of the contract, Stellar Innovations Proprietary Limited approached you for legal advice. The contractor wants to know if it can ask for a judicial review of the Minister's decision under the Administrative Decisions Judicial Review Act 1977 Commonwealth. Give your advice.
Thank you, Maggie. Can I ask everyone to give his or her answer in the chat box, please? From B. Okay, good. 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 So from B, from Libby, and everybody else, no, it's not. You cannot, and even from Vivian, it's a contractual matter. So very good. From Michael, from Kim. So you cannot have judicial review under the ADJR Act because the decision in this case was not based on the enactment, meaning it wasn't based on the Fast Track Infrastructure Stimulus Act. It was actually based on the general law of contracts. So the decision on the part of the minister not to pay Stellar was based on his thinking that the contractor failed to comply with a key condition of the contract. So in that case, the decision is based on the general laws of contract and not the enabling law itself, which was the Fast Track Infrastructure Stimulus Act. So therefore, what you have is a decision which was not based on an enactment. So that's good. Good. Okay, so I'm glad everybody got that right. So we don't have to delve on that. We'll proceed to that. So that's very good. I'm very happy that you got it correctly. So we're going to move to question number 9. Can somebody again read question number 9 for us, please?
I'll read. In Australian Broadcasting Tribunal versus N. Bond, 1990, 170 Commonwealth Law Report, the High Court ruled that the conclusion of the Australian Broadcasting Tribunal that Mr. Bond was not a fit and proper person to hold a proper license and was not a reviewable decision under the ADJR Act. The High Court made that ruling even if the ABT conclusion on Mr. Bond's fitness was determinative of the ABT's other conclusion that licensee companies under Mr. Bond's control were consequently not fit and proper persons to hold commercial broadcasting licenses. How did the High Court arrive at its ruling that the ABT's conclusion that Mr. Bond was not a fit and proper person to hold a proper license was not a reviewable decision under the ADJR Act?
Thank you very much, B. So when you're ready, can I ask you to post your answer in the chat box? Got an answer from Vivian. It wasn't a final and conclusive decision. Okay, so I'm just going to put that down on the screen, not a final and conclusive decision. Okay. And then somebody mentioned B, intermediate decision. Okay, so we're probably ready to discuss this. Let me begin by talking about the intermediate decision, because the intermediate decision means it's not a final and conclusive decision. Okay, correct? So if it's an intermediate decision, it is not yet a final and conclusive decision. Let's begin with the general rule. When we say that a decision is intermediate, does it necessarily mean that therefore it is outside of the scope of the ADJR Act under the High Court ruling in Australian Broadcasting Tribunal versus Bond? What exactly did the High Court say in relation to intermediate decisions? Can an intermediate decision be the subject of judicial review under the ADJR Act? So let me repeat my question. Can an intermediate decision be the subject for an application for judicial review under the ADJR Act as stated by the High Court in Australian Broadcasting Tribunal versus Bond? Can I get some answers here?
Hi, Manjo, it's Libby.
Libby, yes.
Hi. I'm thinking that an intermediate decision can be the subject of review if it is a decision that is provided for under the Act. So it's a necessary decision provided for under the Act in order to make the final determination.
Okay. So that's right. So that's correct, Libby. So thank you. You're right. The High Court, according to Chief Justice Mason, did say, Chief Justice Mason did say in Australian Broadcasting Tribunal versus Bond, that an intermediate decision can in fact be the subject of an application for judicial review under the ADJR Act. So that should be clear. And as Peter pointed out, for it to be an intermediate decision that can be the subject of a, I'm just going to copy the statement of Peter for the purpose of those who will just be viewing the recording. So even if it's an intermediate decision, for as long as it is a decision on a matter of substance, so in other words, the statute provides that it is an essential preliminary to the ultimate decision, then it can be the subject of judicial review under an application for judicial review under the ADJR Act. So thank you for that, Peter. So let's repeat. Even if it is an intermediate decision, meaning it is not a final and conclusive decision, it can be the subject of an application for judicial review under the ADJR Act if it is a decision on a matter of substance. And in that case, we know it is a matter of substance if the statute provides that such a decision is an essential preliminary to the ultimate decision as held by Chief Justice Mason in Australian Broadcasting Tribunal versus Bond. Very good. Okay, now, so how did it happen that the High Court arrived at its ruling that the ABET's conclusion that Mr. Bond was not a fit and proper person to hold a proper license? Why was that decision not a reviewable decision under the ADJR Act? So that decision, was that a final decision or was that an intermediate decision? Let's clarify first. the conclusion of the ABT that Mr. Bond was not a fit and proper person to hold a proper license, was that a final decision or was that an intermediate decision? So it seems to be intermediate. Fine. But we already said that even if it's intermediate, it could still possibly be the subject of an application for judicial review. So, but what's the problem here? Assuming it was an intermediate decision, why couldn't it be the subject of an application for judicial review? Because, okay, why? Was that a question of review findings of facts? So we've got answers here. Was not specifically required to be made by the legislation. The determination was with regards to the, it moved, sorry. The determination was with regards to the companies, not him personally. Okay, Jackie, if you could, you seem to be headed in the correct direction. Do you think you might be able to use the mic to explain your answer there?
Hi, Manjo. Yeah,
Jackie?
In my notes here. Bond wasn't a licensee himself. He controlled the companies in question, and the companies were the actual licensees. So the Act didn't contain provisions for determining whether he was fit and proper. They were looking at whether the companies were. And I think, I'm not sure if I'm right here, but I think that the decision that, or them finding that he was not fit and proper was what they had to determine, in essence, to find out if the companies, because he controlled the companies, to find out if the companies were not fit and proper. So the final decision was with regards to the company, and the one about him was just along the way, a step along the way.
Okay.
Does that make sense?
Yes, it does. Thank you, Jackie. So I was having a problem hearing because there was either a problem with the mic or the problem with my computer speakers. But as correctly pointed out by Jackie, in the case of Australian Broadcasting Tribunal versus Bond, there are actually two aspects to this. So we must remember that the question is really in relation to whether or not a license could be given to the licensee companies. So the question to be determined really was, should licensee companies be given broadcasting licenses? Now, however, the question about Mr. Bond being a fit or proper person was not really determinative of whether or not the licensee companies themselves, therefore, had the requisite, met the requirements of being fit and proper person. So in other words, what happened here was that there is actually a two-step process. The first process is, does Mr. Bond, because Mr. Bond owns these licensee companies. So the first question that needs to be determined is Mr. Bond a fit and proper person? Which is separate from the question of whether or not the licensee companies were fit and proper persons. So even assuming that Mr. Bond is not a fit and proper person, it does not necessarily mean that the licensee companies which are owned by Bond are themselves not fit and proper persons. So that finding as to Mr. Bond not being a fit and proper person is too preliminary, because it would still have been possible for the Australian Broadcasting Tribunal to make a finding that the licensing companies owned by Mr. Bond were in fact fit and proper persons, notwithstanding a finding that Mr. Bond was not a fit and proper person. So as to the first question of whether or not the licensing companies were not fit and proper persons, that had not yet in fact been resolved yet by the ABT. And secondly, the question of whether or not licenses should be given to the licensing companies had also not been resolved. So in other words, as to the intermediate decision in relation to Mr. Bond, that had very little impact on a decision later on to determine whether or not the licensing companies were fit and proper persons, and then whether or not they would have they would be entitled to a broad commercial broadcasting license. Okay, so was that clear? Good. As I said, as far as if Catherine's question was, do we get points for discussing? Yes. So the mere fact that you're joining this session, the tutorial session, and then you're engaging in this tutorial by providing answers in the chat box, that is sufficient for you to gain points. Yep, so from Peter, it did not mean that the company was a fit and proper person. That's right, because it has a separate legal entity. So it's a step along the way. Thus, only the final decision was reviewable as it was enacted in the Act. Okay, very good. So we've got 4 minutes, and I wonder if we have time to discuss question 8, or we should skip that, and because we've only got 4 minutes to go. Should we try to answer this? This is quite a long question, and it might, and as far as the answers are concerned, it might take us, I think, another 10 or 15 minutes. Otherwise, I could just provide the suggested answers later on. We could probably skip it, yeah, because it's really a long question. In fact, there are 2 PowerPoint slides just to go through this question. From Aaron, there's a question: do people have a choice of judicial review or merits review? That's a good point. I would rephrase it, not so much as a question of choice, as in choice per se, but really whether or not which is the more appropriate remedy. Should you apply for judicial review, or should you apply for merits review? That I think is the better question there. And even if when you answer the question of whether or not you should be pursuing judicial review or merits review, it's not as simple as that, because at the end of the day, the question is the question of remedies. So if you were to pursue judicial review, for example, if by undertaking judicial review, because assuming it was a question of law, would judicial review give you, provide the remedies that you want? So for example, if a decision was made by an executive body, and what you want the executive body to do, or the executive officer to do, is to actually grant you certain benefits, it might be beyond the scope of judicial review to order the executive to act in a certain way. This would be the decision, for example, in the case of Green versus Daniels, where the court ruled that even if the application was actually correct because it involved a question of law, still it was not within the power of the courts to order the executive to act in a certain way, and in that particular case, it was not within the power of the courts to order the minister to give the benefits to the applicant. Okay, because as we said, if you speak of judicial review, it's limited. Judicial review is limited to the questions of legality or lawfulness of the decision, but more importantly, the power of judicial review is very limited, because typically it is limited to either affirming a decision of the decision maker or setting it aside. It cannot remake a decision of the decision maker. So judicial review cannot remake a decision of the decision maker. It typically cannot vary a decision of the decision maker. Only merit review is able to do that. Okay, so it's now 8:15, and we're going to be discussing merit review at the proper time, which might be next week actually. Okay, so would there be any other questions before we end tonight's session? So right, as somebody said here, the courts cannot remake the decision. That's according to Vivian. That's very correct. And of course, there are factors according to Vivian, such as ability, expense, and what you hope to achieve. So when you decide whether or not to go for judicial review or merit review, at the end of the day, you're hoping, what exactly are you hoping to happen? Because even if you go to judicial review, if the courts are powerless to grant you the remedy that you want, then it's a fruitless activity. It's useless, because you're not going to be able to get the prayer that you want.
I've got one quick question, Manjo, if you don't mind.
Yes, who would that be? Libby. Yes, go ahead, Libby.
It's Libby. This is probably a really silly question, but it's something that's confusing me. So in a situation where someone seeks a judicial review, and then there's a determination made in as far as that's a remedy is provided as far as it's able to be provided. If one of the parties was unhappy with that decision, they can then appeal, can't they? They can appeal that decision, and then it's no longer a judicial review, it's an appeal case, which then means that...
Yes, that's right. So Libby got it correctly. So you've got, so the moment a decision of an executive is brought before the courts, you have judicial review there. But the moment the court makes a decision that is no longer an aspect of judicial review, it becomes a regular court decision that can then be appealable to the higher court. So a decision, for example, of the Federal Circuit Court can potentially be brought to the High Court, or if you had started with let's say with the Queensland Civil and Administrative Tribunal, a decision of the Queensland of the QCAT can then potentially be the subject of an appeal to the Federal Circuit Court or the Federal Court of Australia, or even the High Court. Now, from Erin, why is the child support agency exempt? Erin, you're asking why decisions of the child support agency are exempt from judicial review?
That's correct.
I'm not sure about that. If the point being that there is a law which says that any decision of the child support agency are not susceptible to judicial review, and I'm not sure if I should be answering this at this stage, probably not. We raised the question of whether or not that law essentially meant to oust the courts of their inherent jurisdiction to review decisions of the executive. Because if it is an ouster clause, that would be deemed to be unlawful and invalid. Because courts, especially the High Court, has a constitutional right or a constitutional power in Section 75 to review decisions of Commonwealth officers. So if it becomes an ouster clause, but we're actually discussing that later on. If it's an ouster clause, that would be invalid. But if it's just a limiting clause, in the sense that the law would limit opportunities for judicial review, then that is fine. So in that case, the courts will usually construct a law as only providing limitations on when judicial review is available, but for the power of the courts to actually review judicial decisions to be ousted, that would be invalid. But I don't want to get into that right now, because we're actually discussing that, I think, sometime in week 10 in relation to ouster clauses. So we'll leave it at that for now. Okay, we'll leave it at that for now. I don't want to get into that because it can become confusing. And I've had student complaints before where we kind of, ended up jumping into topics that were meant to be discussed later on. But I'm just saying that, make a distinction between ouster clauses and limiting clauses. So we'll leave it at that for now. Okay, so it's 8:20. So thank you so much for, again, joining us in our tutorial, and I hope to see you next week. Tomorrow I will post in Moodle the legal memorandum assessment for administrative law. So thank you, everyone, and I'll see you again next week. Have a great week, and have a great weekend soon. Okay, thank you. Bye-bye.